Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. Welcome to the Tenant Law Podcast. I am Michelle Itkowitz, and today we are discussing a recent case where an ex-husband attempted to evict his ex-wife and their child from a home that he owned and she did not own. This actually happens a lot, so I thought we should cover it here on the podcast. Also, as I record this, it's the holidays and families are getting together. So this case seemed to be at the intersection of landlord-tenant law and family dynamics, only, I guess, in sort of a depressing way. But let's look on the bright side. If your family got together over the holidays and had a huge fight about politics and your aunt stormed away from the dinner table, well, I guess that's better than if she owned the house you're living in and, God forbid, tried to evict you. So let's start, as always, by setting the stage with some context. New York courts have long recognized a family exception to eviction since the seminal case in the Appellate Division First Department in 1963 of Rosenstyle versus Rosenstyle. And in that case, it recognized that a wife who had resided in the family home with her husband was not a licensee subject to eviction upon revocation of her husband's consent for her to be there. The court wanted this done in the family court in the divorce proceedings. They didn't want part of the dispute between the family to be pulled into housing court and eviction proceedings. However, a few years later, in another appellate department in this state, in the Fourth Department in 1974, there was a case called Hallaby versus Hallaby, and in that case, it held that the husband could evict his wife as a licensee where the family court had already fully addressed questions of financial support between them. So there's somewhat of a split there. In general, the New York courts have over the years really expanded the so-called familial exception, not contracted it. But if the family exception was just universal, I wouldn't have to make a podcast on it. It still could go either way, depending on the circumstances. So to get our minds better around what are the factors courts look at to set the stage here, we're going to look at cases. Okay, I have a case here that held that an owner could not evict his girlfriend and their common child. And another case that held that grandchildren were not licensees subject to eviction by their grandmother. And another case that held that adult children are not licensees of their parents who own the subject premises. And then another case that held that an owner could not evict his teenage stepchildren. And then another case that recognized the family exception where the petitioner sought to evict a romantic partner as a licensee. There wasn't even a marriage there, finding that the partner was not a mere licensee, but a family member based upon a long-standing relationship. And then another case where the court found that an ex-wife who had resided long-term with her former husband was a family member, not a licensee. And yet another case where the court found that an ex-husband could not use a summary eviction proceeding to remove his former spouse and mother of his child from the home which they shared even after the divorce was finalized, which is very similar to the case we're going to be looking at today. But before we get on to that, let's look at two more cases in the same court system, pretty close to each other in time and not that long ago, to really get our minds around what factors are considered. I think the contrast of these two cases really does the trick. So I'm looking at two cases from the District Court of Nassau County. One's from 2009, and it's called Lolly. And in Lolly, a father-in-law sought to evict his daughter-in-law from a premises as a licensee, and the court did allow the eviction. The father-in-law and the daughter-in-law never lived together in the subject premises as a family, nor was the daughter-in-law financially or socially dependent upon the father-in-law. Furthermore, the subject premises was solely owned by the father-in-law and never belonged to his son, to the daughter-in-law's husband. So that means the property could never become the subject of a dispute between the spouses in the division of marital assets upon the dissolution of their marriage. So the court let the eviction go ahead there, but contrast that with a case 5 years later, also in Nassau County District Court, called Kequani. And in that case, it was held that an ex-sister-in-law could not evict her brother's ex-wife from the family home. In that case, the young woman that they were seeking to evict was brought into the home 1 month after coming to the United States as part of an arranged marriage. And English wasn't her first language. She wasn't employed. And the court held that a petitioner who wishes to oust a family member must resort to the less abrupt vehicle of a regular ejectment action in Supreme Court and not housing court, because the court had determined that the parties were involved in a true family relationship and that housing court was just not where this case belonged. Very interesting, right? Two cases, both involving ex-daughter-in-law, sister-in-law, and the court came down different ways depending on looking at the totality of the circumstances. Okay, so now let's get into today's case. Okay, today's case is called Dave versus Vagela, and it is in the Justice Court of New York in the town of DeWitt in Onondaga County. We haven't looked at anything from up there previously, but it's good law here downstate as well. It's part of our overall jurisprudence. This case also gets credit for the judge in this case unearthing most of the cases I shared with you above. The judge in today's case pulled all that law together. When I decide what cases to feature here on the podcast, sometimes I feature a case that is new, about something that is different or new or interesting, but sometimes I just feature a case that doesn't exactly stand for anything new, but it sums up existing case law of a very important area very clearly and gives us a great overview. And that's what this case did. Again, as always, I'll put a link to the case in the show notes. So this was a complicated case because the husband and wife were legally divorced, and the ex-husband owned the subject premises, and he purchased this premises after the divorce. But the ex-wife was living in the subject premises, raising the couple's 14-year-old son. The ex-husband was suing the wife for eviction as a squatter. He said that she broke in when he was away on an international business trip and started living there. That was the ex-husband's story to the court. And the ex-wife's story could not have been more different. The ex-wife said that the three of them, the ex-husband, their child, and she, were all living in the premises as a family for years, even though they had long been divorced. The wife offered a lot of material into evidence, and I think this is also very important. This is why we look at the details of cases, because it's good to see how other people proved their case. This is what the ex-wife put into evidence. She put in a series of photographs as exhibits, and these photographs depicted the ex-husband, the ex-wife, and their son, and various members of their extended family in the actual premises, in the home, at various recent times, living as a family and celebrating holidays and festivals. For example, there was a photo of the ex-wife ceremonially blessing the kitchen shortly after they moved in, and there was a photo of the ex-couple with arms around one another and posing together in front of the stairs. The ex-wife produced bank statements with her name at the premises address, and the ex-wife produced a tuition bill for her son's school addressed to the subject premises. And the ex-wife had witnesses, and this is always very important. Testimony is always very important when you're trying to prove something in court. If you can get people to come in and testify consistently and credibly, it's always good. The ex-wife had witnesses come in, and one witness testified in a way that supported her story and said he saw the ex-wife in the home cooking and cleaning and saw her possessions there, apparently when the ex-husband was there. This court found for the ex-wife and dismissed the eviction case, and the court held, quote, "The court is persuaded that ex-wife has the status of a family member and is not subject to removal by an eviction case. This is especially true given the fact that she resides in the home with the party's 14-year-old son. Despite the 2010 divorce and the apparent absence of any order of custody or support, the court notes that the ex-husband continues to have a responsibility to support his son, including providing him shelter. Evicting the ex-wife likely means evicting their son as well. This is certainly not something within the purview of a summary proceeding under the Real Property Actions and Proceedings Law, Article 7, i.e., an eviction case in housing court." And this brings up some very important tenant takeaways. But first, let's get the housekeeping out of the way. This is not legal advice, and I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it is terrible because I am asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about. Please subscribe and give us the highest rating. It is time for the tenant takeaway. Tenant takeaway time. These situations call for a case-by-case analysis of the relationships in question and the circumstances under which the parties resided together or were connected with each other, financial considerations, emotional considerations. The takeaway here is that if you find yourself, God forbid, faced with eviction, if there's any personal relationship between you and the landlord which could arguably rise to the level of family or former family, then you may have a defense to that particular eviction case proceeding quickly in housing court, and maybe that case has to go away, in which case the landlord party would have to bring a new case in a regular court, the Supreme Court of the state of New York, for an ejectment action. And the reason that that is sort of a bad thing for the landlord party is that is going to cost a lot more money and take a lot more time. But the housing parts of the court don't want to be used to settle disputes that otherwise belong in another court more appropriate to this situation. In short, a summary proceeding for the recovery of real property, an eviction case, is too blunt an instrument for a family situation. So if you think back to the example of the young woman where the ex-in-laws were seeking to evict, where she had no means of support, where she came to the country for an arranged marriage, and the former family was trying to evict her, even though the divorce was over, even though she didn't have a legal interest in the house, neither was this a pure arm's length landlord-tenant situation that the summary proceedings for the recovery of real property, i.e. eviction cases, were intended to address. I will let the judge in today's case have the last word here. The judge in this case stated, "Since the early days of the family exception, many of our courts have been less concerned with the marital status of the parties and more concerned with whether the household members have resided as a family unit, often with financial and emotional interdependence and an indicia of continuity." And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.